Civil Liberties, Protecting Guaranteed Constitutional Freedoms. This is the first in a series of videos that will discuss the expansion of civil liberties throughout United States history. And it is very hard to discuss the expansion of civil liberties in the U.S. without discussing selective incorporation. Initially, the Bill of Rights was decided to apply only to the national government. The first time the Supreme Court is called upon to even consider this question is in the 1833 Barron versus Baltimore case. And the Chief Justice at that time was John Marshall. He wrote the majority opinion. John Marshall was a former Federalist. He was very much an opponent of the idea of states' rights. And so in his opinion, he says that the only reason that people called for, or anti-federalists called for, a Bill of Rights to be added to the Constitution was because they were afraid of the national government usurping or taking too much authority. They did not fear state governments, and because there was no clear delineation in the Constitution or from the framers that the Bill of Rights were intended to limit states' powers, they could not be considered to limit states' powers. And so this ruling, which basically says that the Bill of Rights applies specifically to the national government, stands from 1833 until after the 14th Amendment to the Constitution is ratified in 1868. So the 14th Amendment was proposed by Congress to protect the rights of recently freed slaves, to overturn the 3/5 clause of the Constitution, in which slave populations were counted as 3/5 of the free population, for purposes of apportionment, or counting the population to elect or to determine how many representatives were going to Congress for that state. They also wanted to keep rebellious Southerners from holding federal office, because this is again part of radical Republican Reconstruction, where they were trying to punish the South for causing the Civil War in the first place, doing everything they can basically to squeeze the South for being bad, essentially. The 14th Amendment is divided. It creates, the first section of the 14th Amendment creates national citizenship, and it contains 3 clauses that limit the power of state governments to interfere with the rights of U.S. citizens. These clauses are respectively known as the Privileges and Immunities Clause, the Due Process Clause, and the Equal Protection Clause. So the first time the Supreme Court has the opportunity to use the 14th Amendment to limit state power is in the Slaughterhouse Cases of 1873. The case comes from a Louisiana law which granted an exclusive franchise to one large slaughterhouse to process all meat in and around the city of New Orleans. This was done to control the dumping of refuse into the Mississippi River, which was polluting the water and causing outbreaks of cholera in the city. The court was asked to interpret the Privileges and Immunities Clause as establishing a national right to practice one's occupation free of a state-created monopoly. In its decision, the court decides to refuse this interpretation of the clause, claiming that the right did not exist before the passage of the amendment and was not something that could be deduced or taken from the clause. Instead, the court read the clause to mean that all citizens of a state may freely travel and establish residence in another state and are entitled to the same privileges and immunities under the state law as the citizens of the state to which they travel. So if you decide to go, let's say, on a college visit to California, that means that you have all of the same privileges and immunities that people who reside in California have while you are there visiting, let's say, a university that you're considering attending next year. So this decision is really important because some historians and political scientists think that it made the Privileges and Immunities Clause very weak, and it reduced the ability of the Privileges and Immunities Clause to protect liberties, national liberties at the state level. The Slaughterhouse Cases proved to basically eliminate the opportunity to use the Privileges and Immunities Clause as a means to apply the Bill of Rights nationally. And so many, many years later, similar attempts using the 14th Amendment would actually be somewhat successful using the Due Process Clause, which prohibits a state from depriving any person of life, liberty, or property without the due process of law. So in 1925, the case of Gitlow v. New York came to the Supreme Court. Benjamin Gitlow was convicted by the state of New York for advocating the overthrow of the government by force. Gitlow challenged this state law on the grounds that it violated the Due Process Clause of the 14th Amendment. In this particular case, a majority of the Supreme Court for the first time accepted the idea that parts of the Bill of Rights apply to state government. The court said that freedom of speech and the press are among the fundamental rights and liberties protected by the Due Process Clause of the 14th Amendment from impairment by the states. The Supreme Court didn't explain how they came to this conclusion, and they didn't say what other rights and liberties it thought were fundamental enough to enjoy protection from state infringement either, so these were all basically decisions that the court left open to interpretation in different cases. Because of this, Gitlow v. New York is the case that is decided as developing in the incorporation doctrine, which becomes selective incorporation. So the court will hear in the future, would hear different cases that dealt with civil liberties and freedoms, and they would decide sort of on a case-by-case basis how the Constitution should be, or the Bill of Rights, should be nationalized to the states. A key case for selective incorporation, some historians and political scientists would consider it the key case for selective incorporation, is Palco v. Connecticut from 1937. The court did two important things in this case that are necessary to remember. The court said that any right, and I quote, found to be implicit in the concept of ordered liberty and so rooted in the traditions and conscience of our people as to be ranked as fundamental would be applied to the states. So essentially, they're not going to say, if the Supreme Court decides that they're not going to totally 100% incorporate all of the Bill of Rights at once, but it does create a guide, which was not found in Gitlow v. New York from the court, as sort of a guide to selective incorporation. How would they decide which rights, what standard or criteria would they use to decide which rights should be applied nationally? So this is a chart that reflects some of the more important Supreme Court cases that deal with selective incorporation. So the Warren Court is incredibly important to discuss when we talk about selective incorporation. Eisenhower's president, he's a Republican. He appoints Earl Warren, who was previously the governor of California, I believe, and everybody sort of expected that Warren would be this guy that followed sort of in the behavior patterns and the political ideology of Dwight Eisenhower. They thought he would be somewhat conservative, and instead he does one of the biggest political switches in U.S. history and ends up, during his time as Chief Justice on the court, incorporates almost all of the first 8 amendments. The Warren Court led a revolution in criminal law procedure protecting the rights of the criminally accused. Mapp versus Ohio, Gideon versus Wainwright, Miranda versus Arizona are some very central cases to this. Mapp versus Ohio deals with the Fourth Amendment search and seizure, which we'll discuss in greater detail. Gideon v. Wainwright requires that people who are charged with felonies not be allowed, or they're at least provided a public defender. You still have the option to defend yourself if you so choose, but they at least have to be provided a court-appointed attorney. And then Miranda versus Arizona, obviously you've heard of the Miranda warning. You've seen it on TV. I'm sure if you ever in your life have watched one police or detective show. And then you have some critical religious decisions, which basically limited the influence of the Judeo-Christian faith in a lot of the public sector, particularly in public schools. So that was critical changes. Okay, so